Section 7. When accused lawfully arrested without warrant, when a person is lawfully arrested without the warrant involving an offense which requires a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted in accordance with existing rules and the absence or unavailability of an inquest prosecutor. The complaint may be filed by the offended party or a peace officer directly with a proper court on the basis of affidavit of the offended party or arresting officer or person. Before the complaint or information is filed, the person the person the person the person arrested may ask for a preliminary investigation in accordance with this rule, but he must sign a waiver of provision of Article 125 of the Revised Penal Code as amended in the presence of his counsel, notwithstanding the waiver. He apply for a bail and the investigation must be terminated within 15 days from its inception. After filing of the complaint or information in court without a preliminary investigation, the accused may, within 5 days from the time he learned of his filing it, ask for the preliminary investigation with the same right of adduced evidence and his defenses as provided in this rule. Section 8. Records. Records supporting the information or complaint. An information or complaint filed in the court shall be supported by the affidavits and the counter affidavits of the parties and their witnesses, together with the other supporting evidence in this resolution on the case. B. Record of preliminary investigation. The record of the preliminary investigation, whether conducted by a judge or prosecutor, shall not form part of the record of the case. However, the court on its own initiative or on motion of any party may order the production of the record or any of its part when necessary and resolution of the case or any incident therein, or when it's to be introduced as the evidence in a case by the requesting party. Section 9. Cases not requiring a preliminary investigation, covered by the rule of summary procedure. A. If filed with the prosecutor, if the complaint is filed directly with the prosecutor involving an offense punishable by the imprisonment of less than 4 years, 2 months, and 1 day, the procedure outlined in Section 3A of this rule shall be observed. The prosecutor shall act on the complaint based on the affidavits and other supporting documents submitted by the complaint within 10 days from its filing. B. if filed with a municipal trial court, if the complaint or information is filed with a municipal trial court or municipal circuit trial court for an offense covered by this section, the procedure in section 3 of this rule shall be observed. If within 10 days after the filing of the complaint, the information shall judge find no probable cause after personally evaluating the evidence or after personally examining and writing under oath of the complainant and his witnesses in the form of searching question and answer, he shall dismiss the same. He may he he may however require the submission of additional evidence within 10 days from notice to determine further the existence of probable cause. If the judge still find no probable cause despite the additional evidence, he he shall he shall within 10 days from its submission or expiration of said period dismiss the case. When he finds probable cause, he shall issue a warrant of arrest from the commitment order of the accused had already been arrested and hold him for a trial. However, if the judge is satisfied that there is no necessity for placing accused under the custody, he may issue summons instead of warrant of arrest. Thank you, sir.